A lot of times, corrupt cops get away with awful and sometimes even unlawful things. But in some cases, the public fights back and sue them. Here are 5 different cases of corrupt cops who finally got sued.
Let me just plea and get it over with for everybody. Plea to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years and years. If you can sleep with it, I can sleep with it.
This is Sheriff Todd Pate, a long-serving law enforcement figure in Breckinridge County, Kentucky. On 15th of March 2019, Sheriff Pate's actions led to a series of events that shook the community to its core. Reports indicate that Sheriff Pate, while under the influence of alcohol, engaged in reckless driving, causing a severe accident that left one individual seriously injured and endangered the lives of several others on the road. The incident marked Sheriff Pate's second DUI offense, with a prior arrest in October 2015. And on the basis of that incident, he was taken to court.
I have previously been tendered executed documents by Mr. Pate that have been likewise signed by his attorney and by the Commonwealth. It is my understanding that through felony mediation that an agreement was reached, that agreement was subsequently reviewed with the victims in this case as well, and that the purpose for today's hearing was to enter that plea consistent with those executed documents. Perhaps I should have directed my questions first at you instead of Mr. Pate. At this point in time, what is Mr. Pate's decision with respect to proceeding forward with entry of his guilty pleas?
So I believe he's still under oath, and I believe I'll just let him answer that question if it pleases the court.
All right. So, Mr. Pate, what is your position today with respect to entering a guilty plea here, consistent with the executed documents that have been tendered to me?
Can I say a few things, or?
I need to understand what it is that we're doing here today, Mr. Pate.
Yes, I had every intention of coming in here today and entering a guilty plea based on the mediation that we had. It's very difficult for me to enter a guilty plea to felony-related charges that I've been in law enforcement for 25 years, and never have I ever charged someone with felony charges on a situation pertaining to this that was similar to this.
As mentioned by Pate, he is meant to enter a guilty plea, but is constantly stalling, to the point where his attorney has to cut in.
If I may interject, just if you intend not to enter a plea, don't say very much about the case, because what you say here under oath will be used against you. I'm not trying to tell you not to say whatever it is you need to say, but also want you to remember that if you don't ultimately plead here, whatever you say, I would think that Mr. Chambers will definitely use against you at any further proceeding. Okay?
Thank you. I was just getting ready to do that. So,
sorry, I did not mean to interrupt.
Mr. Pate.
You know, it's difficult for me to enter a guilty plea for a lot of reasons, and I don't want this court to think that I am trying to minimize, take away from, or deflect any responsibility that I had in this situation that occurred. I do absolutely feel like that because of my bad decisions, that this whole case took a turn that it wouldn't have taken had it not been the Breckinridge County Sheriff. It's difficult for me to plead guilty to felony charges where a prosecutor indicts me and immediately after getting an indictment recuses himself. and basically testifies at the grand jury to facts that were not at all. And again, if I hadn't done what I did and drank and drove on March the 8th, I would not be sitting here, nor would anybody else. But I absolutely think I was indicted. That prosecutor said, got my indictment, I will jump out. Then I made an offer based on those indictments on a Monday. We sent an email back to Mr. Chambers' office to not accept, and 2 days later I'm indicted for assault first, one that if you're found guilty you spend 85% of. This was never an assault first case. Should have never been an assault first case, but it became that, and it became that to push me in a direction to take a plea. I'm willing to take a plea, but I now understand how some people feel. I've defended the court system many, many times and still do, but I feel like I'm being very much bullied into doing something that's not right. Now, the gamble is big. Mr. Chambers wants to go to trial and say, now, let me tell you this, that, and the other. Then I'm risking leaving my family, which I did that March 8th when I drank and drove. Thank God I didn't kill anybody. But I want this court to know, I want the people to know, and I want the public to know that Todd Pate holds himself responsible for everything that he did. But it's hard for me to lay down and plead to felony charges that don't apply.
Despite his huge monologues, the court only wants the answer to one thing: whether he's going to enter the guilty plea or not.
Okay, so I think we are back, Mr. Pate, and probably should have stayed in the place where we started. Again, I wanted to give you an opportunity to have further discussions with your attorney. But I'm sorry, ma'am. No, you don't have.
I'm sorry for.
Eventually, the judge starts to lose patience with Pate.
What I need to, I think we're back to where we were before. Is it your intention today to enter this guilty plea? And I think we're at a yes or no place at that point.
Can I say one more thing? I think everybody in this room wants this over with. And if I could address Blake, I hope you learn from this case I'm not mad at you. I'm not in any way upset with you.
Mr. Pate, we have reached that point now. Okay. This is either a yes or no. Are you going to enter your plea or not?
I guess everybody thinks it's funny.
Well, certainly not the people who I think are here with you today.
No, they don't. I've broken everybody's heart. But it's hard for me when I see Mr. Chambers sitting over there smiling. Let me just plea and get it over with for everybody. Plea to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years and years. If you can sleep with it, I can sleep with it.
Okay. I think we're done. At this point in time, I think we're done. And so let me tell you where I think we are today, is that we have executed plea documents. Whether or not Mr. Pate has the right to withdraw his plea now that he's executed those plea documents remain to be seen. And at this juncture, this court could not, based on these preliminary statements that Mr. Pate has made, make a finding that this plea is knowingly, voluntarily, and intelligently made. Where I think we are today is that on the one hand, the Commonwealth can, if chooses to do so, to enforce the terms of this agreement based on the execution. Mr. Pate, I'm talking at this point in time.
Okay, I'm sorry. Sorry.
After having enough of Pate's antics, she decides to conclude the session.
At this point in time, I'm going to sustain the Commonwealth's motion to revoke his bond. He's going to be taken into custody today. We will come back for further hearing as to whether or not to go forward with this plea or to set this case for trial. And I will look at additional conditions with respect to his bond at that time. He's going to be held without bond based on, at least at this juncture, there having been an executed plea where he was to serve 75 days with credit served. There will not be any arrangements made with respect to house him in Grayson County or anywhere else, that he will be taken into the custody and housed in the Breckinridge County Jail. And at that point in time, if the Breckinridge County jailer wants to make arrangements with another jailer to house him, he can. And then what we will do is we will look at coming back as soon as your respective schedules will permit, in order to hear argument on whether this case should proceed forward on resolution of a plea, or whether it should proceed forward on resolution for trial, and if by trial, then where that case should be tried. We've got a fully executed plea document that provided in pertinent part that he was to serve 75 days in jail, and he's going into jail today under the terms of that plea. Whether or not proceed forward with the court accepting the Commonwealth's offer of pretrial diversion, as opposed to rejecting that plea, which would give him the opportunity to then, of course, withdraw his plea. We got a whole lot of things to sort out, and we're not going to sort them out this afternoon. So if you'll look at your calendar and tell me when you can be back here next week, I can be here Thursday afternoon, I can be here anytime on Friday.
Despite all of his charges, Pate did not serve jail time due to a suspended sentence and payment of a fine. In the current case, Pate was required to serve 75 days in jail, but with credits, he would only need to serve an additional 29 days, as stated by his attorney, Douglas Vowles. Vowles also indicated that Pate entered into a pretrial diversion agreement, suggesting that the charges would eventually be dismissed. If you think that Frank's death at the hands of cops was crazy, wait till you hear about the next case.
You are harassing me. Please stop.
Put your hand behind your back.
I'm not doing nothing. I don't have a weapon.
Put your hand behind your back.
I'm not doing nothing wrong.
Put your hand behind your
Ow,
back.
you hit my head.
This is a North Salt Lake woman by the name of Greta Jensen. In December 2020, a Bountiful police officer was called by Greta and her ex-husband's neighbor on the basis of a domestic violence call. The following took place when he arrived on scene.
Bountiful, 2 Golf 10. We're going to be on 200 east, about 600 north. Hi.
Hey.
How you doing?
Oh, good. How are you doing?
Good. We had a call about a disturbance here.
There's no disturbance here. I'm not here. We're just talking.
Okay. Well, it looks like
We haven't yelled or nothing.
looks like you're trying to talk to someone that doesn't want to talk.
Right from the start, the situation seems kind of unfavorable for Miss Jensen.
No, he had his window down. We've been talking. We had some house stuff to talk about and stuff, and we're just talking. He's just keeping warm, I reckon. I don't know. I didn't ask him to get out.
Well, his window was rolled up. That's weird.
Well, you weren't here the whole time because his window wasn't rolled up. He rolled it up when he turned on his heater.
But the husband himself doesn't seem too bothered by the presence of Jensen, which indicates a false call.
She's leaving and I'm going.
We're not. There's no disturbance. Somebody lied to you. I would get them for false reporting because we hadn't had any disturbance.
Okay.
That I know of.
So are you doing okay?
All good. I'm good. Good. I'm just going in and she's leaving. So.
Yeah, we were just talking about some stuff.
Was there somebody else here? Because I'm confused now.
I am too. We didn't hear anything. Nobody's
Maybe
yelling.
because she was yelling through my window or something.
No, I was not yelling.
Talking loud, excuse me.
No, I was talking just like that. I wasn't talking loud.
What's your name?
Monty.
No, we haven't talked. I talk like this.
Are you guys ex?
Uh-huh.
Yeah.
Ex-wife? Okay.
So we still have some.
Who's the landlord?
Jeremy?
Any idea why he'd be calling?
Maybe she was yelling through the
No,
window.
but maybe I don't know. Monty, I was not yelling. And
Well,
you know
I had the
it.
window closed. Maybe.
No, I was talking. This is as loud as I talk, so you can call that loud. And maybe tell him.
How
to come
far
out
out are
here.
you?
I ain't talking loud. We were just talking, and he hadn't even. We don't have any issue. We were just talking about.
Can I just talk to you inside later in just a
Sure.
sec?
Sure.
Excellent, thanks.
Sure.
Okay.
Greta continues to explain how she was not arguing at all and it's all a misunderstanding.
No, I was just leaving. We were just talking. That's all we were doing. We're not arguing. We're not mad.
Okay.
Nothing.
Can you take your hands out of your pockets for me?
Why?
Well,
You're cold.
can you just keep them out of your pockets, please?
No, I don't have. You don't feel? I don't have
Can you-
anything in my pockets.
Why
Well, don't be
Why
silly.
don't you settle down a little bit, okay? It's something I do for my safety.
If somebody comes up and harassing you, you would get a little like, why are you harassing me? I didn't do nothing wrong. So
Who's harassing you?
It feels like harassment.
I'm just
So,
asking you what's going on. I need
okay.
you to stay here.
I'm not doing anything wrong.
I'm
He
investigating
told
a
you.
potential crime, okay?
There's no, for crying out loud.
Okay.
Now you're
I
exaggerating.
need you to settle down.
There's no.
Based on the information
You know what?
I got,
can talk,
based on the
and
information
you're
I was
not-
given.
You're not in power
Okay,
over anybody.
I'm about to put you in handcuffs if
no,
you don't
you're
stop.
not putting me in handcuffs.
Yes, I am.
No, you're not.
So let me tell you
I've
what the
done
call
nothing
was.
Wrong. I've done nothing.
Let me tell you what the report
I
was.
don't care what the report was. He just told you we weren't doing anything, and we are the two people involved.
Nah, normal speed's fine.
So
we got a call that you were being disorderly out in front of the house.
that's a lie.
That you were shouting at him,
No shouting.
and that you were not letting him get out of the car.
Never did. I was just standing there talking. We were just talking. He never said, move, I'm going to get out of the car. He had the heater on. He turned it off. He started the car back, and we were just talking.
Okay.
And I was leaving. We were about, I gave him a piece of mail that came to the house that he needed. And then we started talking about, we got to sell the house. And we were talking about pricing and just different things.
Okay.
We weren't arguing at all. There was no
Well, can you
argument.
understand how it would look to me when I come walking up here and his window's rolled up and you're being kind of loud?
The cop continues to explain how it all seems a little too suspicious to him.
You know what? I wasn't being kind of loud. That's a lie. You can say it all you want. Don't make it true. Your opinion
Okay.
doesn't make facts true. So
What's your name?
Greta.
What's your last
The same as his.
name? What's your date of birth? Okay.
There is nothing. Go get whoever said that.
Well, that's what I'm
Monty
going
just,
to.
You
as
know
soon
what?
as
Me
I-
and Monty.
Can you just stand
listen,
still, please?
Don't tell me how to move. You're not God.
I just
Get
asked
over
you
it.
to please stand still.
I asked you to quit bossing me around. I'm not doing nothing wrong.
I asked you. I'm not bossing.
You know what you're doing, sir. You
I
know what
asked
you're
you
doing.
to stand
You
still,
know
please.
what you're doing. Stop.
Will you
Your
please?
ego is out of control.
I
Just
said,
stop.
please. Will you please just settle
I'm not
down?
doing anything wrong.
We were having a perfectly
You know
fine
what?
conversation.
Yeah, me and Monty, are we the? Did he tell you there was no problem? Did I tell you no problem?
Well, people.
And we didn't see
Yeah.
anybody.
After a couple of minutes of conversation, the cop decides to go ahead with an arrest.
So I need to speak to people separately when it's a domestic violence
There's
possible issue.
Okay, I'm going.
Stop. Stop. You're under
You know
arrest.
what?
Okay, you're under
No,
arrest.
I'm not.
Put your
Don't-
hands behind your back. Put your hands
Stop
behind
it.
your back.
You're
Put your hands behind your back. You are under arrest.
Okay, I'm not doing nothing.
Put your hands behind your back. Stop
Ow,
resisting.
Ow, you hurt.
Stop
I'm not-
resisting.
I'm not doing nothing.
Stop resisting.
I'm not doing nothing.
Stop
Just
resisting.
Just stop right now.
Stop resisting.
Okay, I
Put your
am.
hands behind your back.
I am. Stop
Put your
right
hands
now.
behind your back.
Stop right now.
Yes,
Stop.
expedite
You're
now.
out. No, you're lying.
Put your hands behind your back.
No,
Put your
I'm
hands
not.
behind your back.
I didn't do nothing, sir.
Put your other hand behind
Please
your back.
stop.
Put
Please
your
don't make
other
this
hand-
something it's not.
Put your hand
I
behind
had
your
shoulder
back.
surgery. Will you stop?
Put your other hand behind
No,
your back
I
then.
didn't do nothing.
Put your other hand behind your back.
Listen, stop. Just stop right now. Stop.
Behind you.
You are harassing me. Please stop.
Put your hand behind your back.
I'm not doing nothing. I don't have a weapon.
Put your hand behind your
I'm
back.
not doing nothing wrong.
Put your hand behind
Ow,
your
you
back.
hit my head. Please
Put
stop.
your hand behind
I'm
your
not
back.
doing nothing wrong.
Put your hand behind your back. Put your hand behind your back.
Hey,
Put your hand
you know what?
behind your
I
back.
didn't do
Put your hand behind your back.
During the arrest, the cop gets a bit too carried away with his use of force.
Oh, ow, that hurt!
Put your hand behind your back.
He's hit me! He's hit me!
On your back.
He's hit me!
Roll over.
He
Roll
just
over.
hit me in the
Roll
face!
over. Put your
Christ.
Roll over.
I didn't do nothing!
Roll
I didn't do nothing! I did nothing! He hit me in the face!
Okay.
He hit me in the face!
Stop.
He hit me in the face, please!
stop.
All I did was walk off! That's all I did!
Yeah.
That's all I did! I didn't do nothing!
Stop. We'll figure it
I did not do nothing!
Okay, we'll
He hit me in the face like 3 times!
We'll figure it
You've got a lawsuit! You've got a lawsuit! You thought you cannot do that to somebody! I didn't do nothing! I did nothing! Get the medical here! Get medical here! Right now! Right now! He busted my jaw! He busted my jaw! I didn't even move my hand! I didn't do anything! On my jaw! This is not my jaw! All I did was just say I'm leaving! He hit me!
He has nothing. I didn't do nothing. You know what? This ain't right. This ain't right. It ain't about being calm. It's about breaking the law. It's about breaking the law. It's about you ain't going to do nothing to him. You know you are not. And look what he just did to me.
Let's give us a sec to work through everything, okay?
You got a lawsuit, buddy. I didn't do nothing. I did not do nothing.
You gotta take this one step at a time, all right? Or
I
how are
did
those
not do
handcuffs
nothing.
feeling?
Did not do anything.
Okay. How do those handcuffs
Did
feel?
not do anything. I didn't do anything. I was talking to him and answering his question. He came up here and me and Monty were talking. We did nothing. We even told him we did
Here's what we're gonna do.
After this incident, Greta had a fractured jaw, as well as a bust-up shoulder. In October 2023, Jensen filed a $1 million federal lawsuit against Officer Joubert, alleging that he violated her constitutional rights by using excessive force when he arrested her. She also argued that she had committed no crime. On March 9, 2021, the Bountiful Police Department held a formal hearing concerning allegations that Joubert had violated several department policies during the arrest. Bountiful Police Chief Edward Beeler issued a written reprimand finding that Joubert striking Greta Jensen in the face was unreasonable and unnecessary. In addition to the written reprimand, Joubert was instructed to attend a remedial defensive tactics class. However, he was not fired from his job as an officer. If you believe that Officer Michael Amot was unempathetic and misused his authority and power, wait till you hear about Sheriff Charles Reeder's case.
Our debit card was put in a machine and the money was taken from our checking account.
Well, obviously, that doesn't answer the question, where did the money in the checking account come from? But no.
At that time, I was making the salary of the sheriff and my wife was making approximately $2,500.
Just asking the question here, that's all.
This is Charles Reeder, a former Pike County sheriff who in 2019 was accused of stealing money from his department's drug busts for his gambling addiction. Reeder was also brought into national spotlight back in 2016 for his gambling. At the time, Reeder had been a part of a case in which 8 members of the Roden family were found massacred in Pike County. Reeder claimed that he couldn't get any sleep because of the case, which in turn led him to gambling.
Your Honor, I stand here before you today to take accountability for my actions. As a sheriff of Ohio, I shed, I shed bad light on the office of sheriff. I can only ask that my staff, their families, the community, and my family who is here today will forgive me for the undue stress I caused them. For this, I am terribly sorry. I stood in this court on September 24th and pled guilty to the charges against me, to accept responsibility for my conduct. That day, within minutes, everything that I'd worked for professionally and honorably for 25 years was stripped of me, with nobody to blame but myself. My staff and I had united with the community and had a partnership and trust. And they truly believed in us as a unit, as a whole. And I betrayed that trust. If I could go back and change it, I would 1,000,000 times. For this is not who I am. Never, ever did I imagine myself on the defense side of this courtroom that I've spent 25 years of my life in this county in law enforcement. As the sheriff, I gave my staff in this community all of me, every ounce of my being. You are aware, Your Honor, that this has affected my mental health as well as my physical well-being. There's nothing left for me to give or to take from me other than my freedom. I have, and I now pray that the court will find mercy on me. And I beg the court, if they see fit, to grant me community control, even with the strictest sanctions that I have proven to this court in the past 2.5 years that I can abide by. I am a good person who made bad decisions and choices. I can continue to be a productive citizen in this county and be in the community with the love that I have for my family, my friends, and my neighbors. I'm asking all this so that I have the opportunity to watch my son graduate from high school and attend college this year. My daughter, who's getting married in October, so that I can be there for her. And my wife, so that I can be a husband that I haven't been in 25 years due to my career. I've just not been there. Given the opportunity, I would be able to spend the time with my mother and my father and continue to be there for them when they need me. In the last years of their lives, as I've experienced this week with my dad, when 2 days ago I thought that I had lost him.
He's still at Riverside, isn't he?
Yes, ma'am.
He's not on a ventilator.
He is on,
He's
on 2 forms of ventilation without the actual
Well, that's
tube.
not what the nurse said, but okay. He's got some oxygen or breathing equipment, but it's not a ventilator. Okay.
I have no words for the shame that I have and that I feel and the regret that I have. Betraying and displaying the trust that I had with my staff and the community. And causing damage to my family's good name. Again, I beg of you to impose a sentence of community service with the strictest sentencing and sanctions. Your Honor, please do not send me to prison. I have roamed, but I'm not ruined. I still have a lot of good left in me. I thank you for your time.
It's evident that Mr. Reeder has committed a dishonorable offense, and although Mr. Reeder asks for forgiveness, the gravity of the crimes he's committed leaves little room for leniency. The only appropriate consequence for such a misconduct that would be accepted by the judge, citizens, and the law is imprisonment.
I have a couple of questions for you. The big question I have, and is on everyone's mind, I'm assuming, is why did you cut open these evidence envelopes and take the money out, and then in some cases you put it back, although you were caught because the envelopes had been unsealed and sealed again improperly, and the denominations did not match what was taken at the crime scene or from those individuals. I guess, why did you take the money?
I took the money, and mind you, this does not excuse it, but from drug dealers that took it from parents of very poor people in this county. That money, regardless of what the state and what the media has claimed in the past years of a gambling problem and that money being used for gambling, was used when there was a tree planted in the name of the Shelton boy. It's at the entrance of Western High School to the left as soon as you pull in. Nobody could pay for that tree. Nobody offered to pay for that tree. A drug dealer did. When schools had cheerleading or pee-wee that had car washes and such, I would have our cruisers taken down there. My men and women did not make good money, so some of them would give them $2, $5. I took money from that and I provided it to those people. Now I replaced it in time. The money was not in the safe the day that they came and they did the search warrant in my office. 3 days prior to that, which the state has not included, I had knowledge from my secretary, Kelly Sanders, that the security company was coming into my office, and that office was going to be open to anyone. I removed those monies from that safe, and I put it in the back of the F-250 that I drove. Now, the day they did the search
I'm
warrant,
sorry, and it would be safer in the lockbox in your car than it would be in a safe?
In an open office?
Which only you have, and a few other people have the combination?
well, ma'am, no one should have had the combination but me. And it strikes me odd that Lieutenant Burchett at the time would make a statement to the state that he'd never seen the accordion file that I provided the state. I did so only on the direction of Chief Michael Spirits, who'd worked for the state at the time, who asked me if I had a comprehensive list of all monies that was in that safe, and I did not. Due to the prior sheriff, when there was an officer-involved shooting that involved his brother, that sheriff resigned, and I took over that office. When I swore him in as a special deputy, he left 2 black marks leaving that office. He handed me the keys. He never did an inventory of the safe, never provided any paperwork of what was in that safe, the money in that safe, or anything. I find it odd that in their search warrant, their confidential informant tells them everything to do with my office, where the safe is, that I have members of my staff telling them that they have never seen anything like that in my safe, which would only be suspect to the fact that they had gained entry into my office and into my safe to have that information to provide to the state. I did what Chief Spirits asked me to do. I organized and made a list of every envelope and every dollar that was in that safe, including the name of the defendant, the date that it was taken, and provided to the state at my attorney's office, to the point that I had to lend my knife to them to open these packages so that they could be counted. My attorney was called away for court, and I continued to stay in that office and assist the state in counting the money. To my knowledge, there was none of the envelopes that didn't contain the right denominations of money. Their discretion or their objective is that the money from a video that was counted appears to be different than money that was in the envelopes that they seen.
Well, from the video, from the PSI, the video shows on different dates, officers counting out money, in one instance yourself, coming to $7,000, for instance, and then turning it over, and there was like $600 short.
And ma'am, Your Honor, I advised my attorney I would take a stipulated polygraph on the $1,000 that I provided on that particular case, that the state now has a cashier's check for $1,000 for State versus Carter. At that scene on Rainbow Trail Road, I was with Lieutenant Burchett. It was videotaped. It was videotaped of Mr. Carter opening a locked door. There's a videotape that exists. Opening a locked door so we could prove that that door was locked and that Mr. Carter had a key. We entered that. It was being videotaped by Lieutenant Burchett. Mr. Carter pointed out where those funds were. They were in some sort of little container, if I remember correctly. They were pulled from that container and counted. They were taken to the back of that same F-250 and placed in the same lockbox in that F-250, where Mr. Carter got in the front passenger side of my truck with me. Lieutenant Burchett followed me in his vehicle directly to the office without stopping. We got to the office. I provided Lieutenant Burchett with the entirety of those funds. So where the $1,000 mistake comes in, I have no idea whether it was a counting error. I have no idea, but I would agree to a stipulated polygraph.
But you pled guilty.
I did, ma'am. Yes, Your Honor. And you're asking me, and I'm giving you the explanation. And I have paid the restitution.
I understand you've given, yes, your attorney the
But
full
that particular case,
restitution that was due and owing in excess of $4,000.
$4,850, Your Honor.
That's been done today. All right, I want to go back to, all right, in the PSI, the pre-sentence investigation, it indicates what you're saying here as to why you claim you used the money for various charitable community things. And then, but the PSI officer notes that there's no documentation that you used it for those things.
Right, I did not document those
Okay,
things.
now, I want to ask you about this. All right, that's your statement, what you say you used the money for, and, okay, that's on record. But I do want to ask you some other things here. Okay, the majority of the acts in this indictment took place between June 2017 and July of 2008. June 2017 and September 2017. Okay. The state obviously alleges in their brief that, particularly since you do not have any documentation of that you use this quote for charitable purposes, they secured your bank records and credit card records and all of that. And it indicates, did you lose $3,000 gambling at the Scioto Downs Racino between June 2017 and September 2017?
Yes, not by myself. They have cards. And of course, again, Your Honor, I've pled guilty to this. But they have cards that you put in a machine. I can have a card in my name, and I can have a card in my name that my wife possesses. So I can be at one machine and she can be at the other. And the money that she spends and the money that I spend, they count on the same card and calculate the money as one. Now, the state has my financial records. They will see that when we are at those casinos, and I have not been to one since and will never be at one again, that the money was taken, that our debit card was put in a machine and the money was taken from our checking account.
Well, obviously, that doesn't answer the question, where did the money in the checking account come from? But no.
At that time, I was making the salary of the sheriff and my wife was making approximately $2,500.
Just asking the question here, that's all.
A pay.
Okay. Also, I want to ask you, in late June 2017, you took a trip to Reno, Nevada for the sheriff's conference, and then you withdrew $2,800 in an ATM. This is in addition to the expenses related to the trip for which you were not reimbursed until later. You see where the state believes that some of this is due to gambling. I mean, you're talking like over or almost $6,000 in a couple of months that you lost or expended on gambling.
And at that point, we were making almost $11,000 a month. And that again was from my checking account where it should show my direct deposits, my wife directs deposits, and that it came from our debit cards where I retrieved that money.
I don't doubt it came from your debit cards. The question is, where did the money come that went into your checking account? I guess that's
where the media reported that I had marital problems because it came from our joint bank account. My wife made very good money at the time, and I took that money and I gambled.
Okay. All right. That's all the questions the court has.
Thank you, Your Honor.
Thank you. All right. I initially want to say, first of all, I have sentenced a number of public officials. Every case is different. No two set of facts are the same. In deciding what I believe is an appropriate sentence, the court has looked at the purposes and principles of sentencing. I've read over the briefs submitted by the attorneys. I've read over the pre-sentence investigation. You know what? I have one more question for you.
Yes, Your Honor.
Here it is. Okay. Now, the thrust of some of the letters, especially from Ms. Kraft, the licensed social worker.
Yes, ma'am.
Who didn't start to see until March 2019. Talks about the stress from all these cases, all these criminal cases, the rodent murders and whatever. Did you ever tell your counselors about stealing from the evidence envelopes?
Yes, we discussed that.
I'm sure there was a lot of stress and sleepless nights you had in terms of your post-traumatic stress syndrome or your anxiety caused by the fact that you opened up these envelopes and took money that didn't belong to you.
Yes, Your Honor. I was being treated since 2013 for those conditions, and it progressively got worse.
Well, it got worse during the time period in which these offenses occurred, and in 2016, starting the investigation of the rodent homicides. But I wanted to ask you that because from what I can tell, the social worker never mentioned anything in there as a stress factor. She just focused on your police work. And I would think, as I said, if you committed a series of thefts, wouldn't that cause stress? No, Mr. Boldrell, let him talk.
I didn't want him to interrupt you, Your Honor.
Okay, go ahead.
I apologize.
No, go ahead.
I believe in the last letter that she provided, she spoke of the court cases and the stress and things that I was encountering because of that as well. I'm unsure. I believe I provided that to my counsel.
Yes, but that's again in terms of the stress over this case, which has caused, I'm sure, untold trauma for you and your family. It's always the unintended innocent victims, the families, that actually suffer the most.
In 2020, the accused, Mr. Charles Reeder, faced a series of felony charges, including theft in office and tampering with evidence. Accepting the responsibility for his crimes, Charles Reeder pleaded guilty. Then, in a decisive courtroom moment on March 24, 2021, in Waverly, the judge sentenced Reeder to a total of 3 years in prison. 1 year for the 2 counts of theft in office, and 2 years for the 2 counts of tampering with evidence. If you think that these officers from Adams County Sheriff's Office were corrupt, wait till you see the officers involved in this case.
You cannot search my vehicle.
I'm not trying to search your vehicle.
No, don't open up my door.
Sir.
I'm not going to let you open up my door. Now, what is the problem? I'm sitting here. You just guys been sitting here as long as I've been sitting here. You walked up to him and asked about no beer on the ground.
This is Douglas Babitt, a 51-year-old Oakland resident and former Army reservist. On a chilly January evening in 2015, Mr. Babitt found himself in a troubling encounter with law enforcement outside a 7-Eleven on East 14th Street in San Leandro, California.
Did I say it was your beer?
Yeah, you asked me it was my beer.
Right.
Now, how am I going to put a beer way over here? I'm sitting over here.
Well, who does it belong to?
Won't you ask the person who put it there? Because I don't know.
Well, do you know who put it there?
No.
Okay.
Anything else you want to ask me?
No, but why are you so aggravated?
Because you come over here asking me about a beer that's not mine.
The officer kept trying to prove in some way that the man was drunk, but the Babitt kept denying.
Well, that's why I was asking you whose it was.
I don't know who it is. That's what I told you.
Did somebody, well...
I don't know who put it there.
Well, that's what I was asking if you saw who put it there.
I'm not security here. Okay? I'm just telling you the facts.
Okay. Sir, would you do me a favor and hang up the phone, please?
No, I'm not going to hang. I want this person to hear what you're talking about.
Okay. Well, sir, you're being recorded on video.
That's fine. I want him to hear it, too.
Okay, well, who's on the phone?
My friend.
Okay.
Okay,
well,
now, I ain't did nothing wrong. I ain't did one thing wrong, so why are you bothering me? You keep on saying the beer on the car, in the ground. The beer is not on my van. It's not in my van.
Right, but now based upon your aggravated demeanor...
I'm aggravated because you're bothering me.
And again, the officers make their false claim of the man being drunk.
Well, it appears to be like you're under the influence.
I'm not under the influence.
Can you just open your door for me, please?
You cannot search my vehicle.
I'm not trying to search your vehicle.
No, don't open up my door.
Sir.
I'm not going to let you open up my door. Now, what is the problem? I'm sitting here. You just guys been sitting here as long as I've been sitting here. You walked up to him and asked about no beer on the ground. And you can bring your breath analyzer over here and I'll take it.
Go ahead with the last 4.
I ain't had no alcohol.
Okay.
Last four.
Why are you so aggravated?
Because you come to ask me about a bill on the ground that's not mine.
Okay.
Okay, that's why I'm aggravated. Just simple as fact. I ain't did nothing to nobody here.
Can you step up the cover?
No, you can't come in my car. Why you got? What cars do you have to search?
Sir.
What cars do you have to search?
Sir.
And then the cops decide to escalate things by trying to arrest Babitt.
Sir.
Wait a minute. What kind of cars do you have to search? You don't have no reason to search. No, I'm not going to resist. Why are you searching? JC, you hear this?
You're under arrest right now.
Why am I under arrest? I'm not drunk.
Bring your right
I'm
hand
not drunk. Wait a minute. I'm coming up. Don't twist my arm. I got body pain. My hands hurt.
All you have to do
I'm not
is
drunk.
all you have to do is bring your right hand behind your back. Bring your right hand behind your back, sir.
Get your DUI thing. I'm coming up. You hurt my hand. Wait a minute. What are you guys doing? Stop. No, I'm not resisting.
Get down on the ground. Get down on the ground. Get down.
Stop resisting.
Sir, stop resisting.
Stop resisting.
Stop resisting.
Stop resisting. Just bring your hand behind your back.
Sir, put your hands behind your back now.
Last unit.
Bring your hand back here. We got it.
Copy 3022, office 333.
Throw them on the side.
Fire my one detained in 71.
1 out of 21.
36. And medical.
1 detained to start medical. Start emergency.
Hey, you alright? You just passed me out.
Yeah.
Oh.
You're right.
In response to the incident, Mr. Babitt pursued legal action, filing a lawsuit against the city of San Leandro and the involved officers, alleging violations of his constitutional rights, excessive force, and false imprisonment. And Mr. Babitt actually won the case, proving that the beer can wasn't actually his, nor was he under the influence.
Get off of the tractor now.
You don't have no warrant. Get off the tractor, dude. Get the f*** off.
Come on out of this, man. Get off the goddamn tractor. Taser deployed. God damn it, get it. Get off the tractor, now!
This is Armando Frank, a 42-year-old individual with a history of encounters with law enforcement. On the morning of October 20th, 2017, in the bustling parking lot of a Walmart in Marksville, Louisiana, deputies from the Avoyelles Parish Sheriff's Office were drawn to a figure seated atop a tractor, identified as Mr. Frank. Their interest in him was drawn by his presence on several outstanding warrants, adding tension to the encounter.
Hey, Mr. Frank. My name's Sergeant Daniel with the Avoyelles Parish Sheriff's Office. How you doing, boss? All right. You mind if I talk to you real quick? First of all, you got an ID so I know who I'm talking to? I can't take your word for it. I got to make sure. All right. Appreciate it, man. I understand you're a veteran. Both of us are, too. You mind coming on down and talk to us over here real quick?
Oh, well, please.
I need to talk to you over here real quick. Need you to get off the tractor, sir. You're coming off the tractor, Mr. Frank.
Get off the tractor. Get off the tractor.
Mr. Frank, I have a warrant for your arrest.
What?
I don't know what the warrant's for, but I do have a warrant for your arrest.
What was that warrant?
It's at the sheriff's office. We can discuss it when we get there.
Let's go see it.
We are going to see it. You're coming with me to see it.
Without proof of the warrant in any way, Frank decides to resist the arrest and ask more about it.
I'm not leaving this tractor.
Get off the tractor, sir.
Okay. Who sent the warrant?
I'm sorry?
Who sent the warrant?
I don't know who signed the warrant.
Then why would you have a warrant for me?
It's at the office. We can take a look at it when we get there. I'm not the one who got the warrant made.
Now what warrant would you have?
Mr. Frank, the warrant's at the office. We'll see it when we get there.
What warrant would you have? Show me one.
It's at the office. I'll show it to you when we get there. Don't have it with me.
Because the cops did not have the warrant, Frank decides he isn't going to cooperate. However, by law, the cops don't actually need the warrant physically present to arrest someone.
No, you can't arrest me.
Yes, sir, I can.
No, you need to show me a warrant.
Get off the tractor.
Show me a warrant.
Step off the tractor. Sir.
Okay.
Step off of the tractor, I'm gonna take you. Get off the tractor. Step off of the tractor.
You don't have no warrant.
Step off of the tractor.
Show me a warrant.
Mr. Frank.
Although Frank was being uncooperative, the cop decides to make things worse by escalating things immediately.
It's confirmed?
Yeah.
No, it ain't.
Get off the tractor, Mr. Frank. Get off of the tractor now.
You don't have no warrant.
Get off the tractor, dude. Get the f*** off.
Come on out, SUED.
Get off the goddamn tractor.
Taser deployed.
God damn it, get it. Get off the tractor, now! Oh, God damn it!
2 days deployed.
No. What's his location? Follow up on time.
Step off the tractor! Get off the tractor! 10-4, we're still fighting. Get off the tractor, now!
123
Get off the tractor, Mr. Frank.
You're also in dispatch. Sure, that. What's that location? Follow up on time.
Walmart parking lot. 3 uses of taser.
Hit him with that taser, did you? Yeah, probably.
132, Sheriff's Office headed to Walmart.
Come on, Mr. Frank, move your leg. Get off the tractor. Are you on his other leg?
No.
I got his shoulders. Good. Stop biting us, you're making it worse. Why not? Still trying to get him off the tractor.
Yeah, walk out of duress.
Mansour parking lot on the side of the building.
I got yeah. Let me out. Let me out. Quit resisting. Come on. Drag him out. Got him?
Oh, Flynn, we dragging him out.
Put him out. Let him go. Put him in cuffs. Go for it, 10-15.
Outside the building. Code 4.
10-15.
Get him up.
Careful, I do that for you.
He's there waiting us.
He's there waiting.
Where the heck goes the bottommost problem? Gotta get that.
Right here.
Right here.
Put him in this.
No, bro.
It's all right. You all right, Bubba?
Oh, yeah.
You all right? You all right?
Yeah, I'm good. Why not?
The situation took a dire turn when Frank started getting breathing issues, prompting deputies to swiftly summon medical aid. Despite their efforts and the subsequent transfer to a hospital, Frank tragically passed away. As a result of this, Frank's family sued the cops involved. Although the doctor who initially attended to this case ruled Frank's death as a homicide, the court wasn't convinced. On the 13th of June, 2022, U.S. District Court Senior Judge Dedrell dismissed the lawsuit with prejudice, meaning it cannot be filed again with the court. He ruled the officers did not use excessive force and said there was no evidence they intended to harm Frank. But the corruption, misdemeanors, and the act of misusing authority by the police don't end here. Next is the horrendous case of Daniel Saylor.
Your Honor, I don't really know what to say to you. I still believe what I said was the truth. I'm a single father with a daughter. I've served my country in the state of Florida for many years, and I find myself in this position now. I don't know what to say to Your Honors. Please have mercy on me.
This is Daniel Saylor, age 58, a former Windermere police chief who was first arrested in January 2011 for covering up the rape case of his friend, Mr. Bush. Daniel Saylor pleaded no contest to official misconduct and served less than a year in jail. However, soon after, Saylor was charged with perjury for allegedly providing false testimony during his friend Bush's trial back in January 2011.
I want to thank you again for your time and consideration of this case. I also wish to tell you some special privileges enjoyed by jurors. No juror can ever be required to talk about what happened in the jury room except by court order. For many years, we have relied upon jurors for consideration of difficult cases. Therefore, the law gives you this unique privilege not to talk about your votes, your discussions, your deliberations for as long as you wish it. You're now free to speak with anyone you'd like about this case. You're also free to refuse to speak with anyone. It's completely up to you individually. With that, you can follow the deputy out. Any legal reason we cannot proceed to sentencing? State argument as to sentencing.
I do have a score sheet if I could approach, Your Honor.
You may. Defense, do you wish to handle the VOP at the same time?
Yes, Your Honor.
No. CF 11518. Mr. Saylor, you're still under oath. Is it true that you were in fact on probation for 4 counts? Official misconduct, solicitation for official misconduct, and tampering with evidence. Is that true?
Yes, ma'am. Yes, ma'am.
Were you in fact placed on probation on June 30th, 2012?
Yes, ma'am.
Finding that, I will find that your admission is on that particular issue and find that there is a violation as to violation of Condition 5.
And Your Honor, just for record purposes, for the purpose of the violation of probation, we would object to the same evidentiary issues that we did in the trial.
Understand, thank you. State argument?
Yes, Your Honor. The defendant has been found guilty of perjury. I know Your Honor heard the testimony over the course of the last day and a half. The state believes that while not statutory aggravators, the factual aggravators in this case are the nature of the proceeding, not only the fact that it was designated by the legislature as a capital case, but that there were 2 young victims involved who did testify. And as I stated in closing arguments, I don't believe there's any other way to read Mr. Saylor's testimony other than it was designed to impact their credibility before the jury. Thankfully, the jury found Mr. Bush guilty in that case. To compound that, you have the fact that he was in law enforcement for many years, and as he admitted on the stand, was very aware of his duty and oath to tell the truth, not only as a law enforcement officer, but especially when testifying before this court. And finally, as Your Honor just noted, for the record, he was on probation to boot when he made these statements. So I will leave it by saying that Your Honor knows that every day we do criminal cases in this courthouse. And if people do not tell the truth, then the system of justice we have will not work. It's impossible. Mr. Saylor knew that, and regardless of that fact, in all his years of experience, he got on the stand and told a lie. I'm not going to make a formal recommendation as to the years. Your Honor has a score sheet in front of you. You know all these scores. The state would just ask that Your Honor weigh the testimony and evidence in this case and render an appropriate sentence.
Thank you. Defense argument.
Mr. Sherman, would you address the court to the sentence?
Your Honor, I don't really know what to say to you. I still believe what I said was the truth. I'm a single father with a daughter. I've served my country in the state of Florida for many years, and I find myself in this position now. I don't know what to say to Your Honor. Please have mercy on me.
Your Honor, just briefly, I have reviewed the score sheet. We have no additional deletions or corrections to make to it. I always think it's difficult, Your Honor, when there are witnesses who testify in court, and cases like this would seem to stifle certain witnesses from testifying in cases because of the ramifications of that testimony. The court will call the evidence from the Bush case in 2003, which was the basis of this statement. There was no evidence that Natasha Bush had ever made any sort of allegation of a sexual abuse. That didn't occur in 2009. I believe the state's position that somehow this affected whatever the outcome of the case in regards to Natasha Bush isn't true based on the fact that there was no such evidence back in 2003. I understand that Mr. Saylor was convicted here today. We would ask the court to follow the guidelines in sentencing Mr. Saylor and give him a concurrent sentence on violation of probation.
CF133900, the court will adjudicate you guilty as the jury found you to be guilty. Sentence you to 8 years Department of Corrections credit for 13 days that you served. In CF1151A, as to the 4 counts, the court will adjudicate you guilty, will revoke and terminate your probation. In each of those counts, will sentence you to a 4-year Department of Corrections sentence. Each count to run concurrently, in each case to run concurrently. That's credit for 15 days that you served. Because all the statutory court costs, fees, costs of prosecution, those amounts of money will be sent to collections court for you to start making payments within 180 days of your release from custody, no less than $30 a month until it's paid off. You have 30 days in which to appeal the judgment and sentence. If you cannot afford an attorney will be appointed to represent you, then the appeal has to be ready in those 30 days. Do you understand that, sir?
I don't understand how many years I got, Your Honor.
8 years total. It's 4 years concurrent on the violation of probation.
Your Honor, as for the credit for time served, the violation of probation, it's my understanding that you had served a year in jail in that matter.
Is that your understanding, State?
Yes, I believe the sentence was 51 weeks work release, is my understanding.
And that should be 51 weeks and 15 days. That's not showing. Thank you.
Thank you.
Good luck to you, sir.
An Orange County jury set for Mr. Saylor's case took a considerable amount of time, 1 hour and 15 minutes to be exact, before reaching a verdict. The nature of his offense left little room for doubt, demanding a verdict that would serve as a firm example. Mr. Saylor was sentenced to 8 years in prison, and he was escorted to Orange County Jail to serve his time. But if you think that cops getting sentenced for exploiting their power stops here, then you must be in the dark about the case of David Oliver.
Mr. Oliver, you did stipulate to the facts in this matter.
I did. The facts as they were written on paper by other officers. And I want to stay with a no contest plea, Your Honor. I'm doing it with a clear mind.
This is David Oliver, aged 56, who became the Brimfield chief back in 2004, amassing a significant social media following through his Facebook page. However, His tenure took a challenging turn in 2015 when allegations surfaced of mistreatment toward a female officer, Crystal Casterline, within his department. This led to a civil lawsuit being filed against him by Casterline, and then later escalating to federal court proceedings. Ultimately, the case was dismissed in 2017 following a settlement agreement. Nonetheless, Oliver found himself entangled in further legal proceedings related to his involvement in the scandal and an attempted theft in office.
Mr. Oliver, I'm going to ask you some questions. I need you to answer yes or no. How will you please stand?
Judge, you want us at the podium or?
Please stand right there, guys. Sir, have you been informed by your attorney and do you understand the nature of the charges to which you're pleading, which would be count 1, attempted theft in office, a misdemeanor of the first degree, count 2, simple assault, a misdemeanor of the first degree, unlawful restraint, a misdemeanor of the third degree, and unauthorized use of property, a misdemeanor of the first degree?
Yes, sir.
Do you understand each of the misdemeanors of the first degree may bring with them up to 180 days in jail and up to a $1,000 fine in court costs?
Yes, Your Honor, I do.
Do you understand the misdemeanor of the third degree may bring with it up to 60 days in jail and up to a $500 fine in court costs?
Yes, Your Honor, I do understand.
Sir, do you understand you do have a right to a trial in this matter, either to the court or to a jury?
Yes, Your Honor, I do understand that.
Are you waiving that right today, sir?
Yes, ma'am.
And sir, did you sign a certain waiver right to jury trial?
Yes, ma'am.
And did you do so voluntarily?
Yes, ma'am.
Sir, do you understand you have the right to confront and cross-examine witnesses against you?
I do understand that too, Your Honor.
Are you waiving that right?
Yes, I am.
And sir, do you understand you have the right to subpoena witnesses to come in and testify on your behalf?
Yes, ma'am, I understand.
Are you waiving that right?
I am, yes.
And sir, do you understand it is the obligation of the prosecutor's office to prove you're guilty on that?
Yes, ma'am.
Are you waiving that right?
Yes, ma'am.
And sir, do you understand you're not required to testify against yourself?
Yes, ma'am.
Are you waiving that right?
Yes, ma'am.
And sir, do you understand by entering a no contest plea with a stipulation to a finding of fact, you waive your right to appeal any issue that may have been brought up at trial?
Yes, ma'am.
And you are waiving that right, sir?
Yes, ma'am.
And sir, you signed a written plea of written plea of no contest waiver rights document. Is that correct?
Yes, ma'am.
4 or 5 pages long?
Yes, ma'am.
Did you sign this document voluntarily?
Yes.
Did you review this document thoroughly with Mr. Pierce?
Yes, I did.
Do you have any questions at all regarding anything contained within this document?
No, ma'am.
And sir, you are a U.S. citizen?
Yes, ma'am.
Sir, I've briefly gone over your rights with you. I know Mr. Pierce has gone over your rights with you. You've gone over. Do you have any questions regarding your constitutional rights?
No, ma'am.
Do you waive those rights at this time?
Yes, ma'am.
And sir, to the charge in count 1 of attempted theft in office, misdemeanor of the first degree, how do you plead?
No contest.
Sir, to count 2, simple assault, misdemeanor of the first degree, how do you plead?
No contest.
Count 3, unlawful restraint, a misdemeanor of the third degree, how do you plead?
No contest.
And count 4, unauthorized use of property, a misdemeanor of the first degree, how do you plead?
No contest.
And you are stipulating to a finding of fact, is that correct?
That's correct, Judge. We would consent to the court making a finding of fact.
The court will make a finding of fact, find that the defendant was a peace officer at the time of this incident, and based on the reading of the facts, the court will find the defendant guilty of count 1, attempted theft in office, misdemeanor of the first degree. Also, the court will make a finding of guilty on count 2, simple assault, misdemeanor of the first degree, based on the reading of the facts. Based on the reading of the facts, the defendant will be found guilty of count 3, unlawful restraint, misdemeanor of the third degree, and count 4, unauthorized use of property, misdemeanor of the first degree. The defendant will be found guilty based on the reading of the facts. At this time, the court will proceed with sentencing. Before the court sentences the defendant, I'd like to hear from defense counsel.
Thank you, Your Honor. Mr. Oliver, as I think everybody in this room knows, served the township of Brimfield first as a police officer and later as a chief. He served approximately 10 years as the chief of police. As everyone knows, Brimfield is a small town that has its own small town politics. I think politics have played a role in this case. And Mr. Oliver is at a point where he has decided that it would be in his best interest and in the best interest of his family to resolve these matters with no contest pleas to misdemeanor offenses. He's done that for both his sake and his family's sake. I know that there are going to be statements made in this case by, I think, Ms. Casterline. I think, as everyone's aware, there is a civil suit that is pending that Ms. Casterline has filed against both Mr. Oliver and Brimfield Township. There will be more litigation to come, but Mr. Oliver's motivation in resolving these is to attempt to achieve some closure for both himself and his family. This has been an extremely rough time for them. And I would indicate Mr. Oliver has done a lot of good for the community. Some of that good is a matter of public record. Some of the charity work that he's done, some of the proceeds from his book that was referenced. There are some David Oliver supporters. I suspect that a lot of people in this room today are not here to support him. But Mr. Oliver is certainly willing and wanting to move on with his life and his family's life, and that was the motivation for these pleas today.
The attorney representing Mr. Oliver advocates on his behalf, portraying him to be a beneficial member of society who has positively contributed to both the community and the police department. Despite the lawyer's audacious claim that Oliver's actions were motivated by the need to safeguard his family, it's important to remember that theft from the police department cannot be excused under any circumstances.
Mr. Oliver, would you like to make a brief statement?
Your Honor, I was chief for the Brimfield Police Department for 10 years, 10 months. There was a collective bargaining contract in place for the entire time I was there. There was never one grievance filed. Never one. This year we entered into some pretty tense, in 2014 we entered into some pretty intense contract negotiations where I requested pay cuts from the officers due to a 12% increase in insurance. The officers refused to take that cut, and negotiations got pretty tense. Nothing was said about any of this. Some of this information dates back to 2012. I mean, and I'm not going to be long, Your Honor, but one question I would ask is if there was a sworn police officer who thought there was a crime that had been committed in 2012, why didn't he report it? The secondary thing about this is I never heard anything about a hostile work environment or assault, or I will guarantee you that Crystal punched me as much as I punched her. That's the relationship we had. Her children spent the night with me and my family numerous times, all the way up to September 2014. Then we had the layoff notices came out, and she was on the list. And as soon as we worked out the contract and rescinded the layoff notices, 2 days later, I got the hostile work environment charge and a threat from the union for a no confidence vote. There is no way in the world that I could have brought this case to a jury with 3 or 4 police officers, what they were going to testify, and run the risk with a jury. I just couldn't do it. So this whole thing befuddles me. I've never seen anything like it. There are officers here today who used to work for me that have shown up just to grind it. One that I fired, well, I mean, when you are the boss, you don't make a lot of friends. So,
Mr. Oliver, you did stipulate to the facts in this matter.
I did. The facts as they were written on paper by other officers. And I want to stay with a no contest plea, Your Honor. I'm doing it with a clear mind.
Anything else, Mr. Pierce, you'd like to say on behalf of the defendant?
No, Your Honor. Thank you.
I was thinking this morning about how I was involved in Shop with the Cops in Brimfield, and you were the head of that program. And the little children were so happy. They loved doing the Shop with Cops. And love going to Applebee's. I'm thinking now how you let those little children down. You've let the people of Brimfield down. You've let your family down. You let law enforcement down. You've become the moat that you wrote about in your book. Do you realize that? I'm going to take the recommendations of the Assistant Attorney General in sentencing the defendant with a proviso of probation, just based on what she felt was appropriate and what the attorneys agreed to. I hope this never happens again to anyone else. I hope no one else comes forward. That would be a huge letdown to everyone in law enforcement. On the attempted theft in office, misdemeanor of the first degree, I'm going to sentence the defendant to 180 days in Portage County Jail. On the simple assault, misdemeanor of the first degree, I'm going to sentence the defendant to 180 days in Portage County Jail. On the unlawful restraint, misdemeanor of the third degree, I'm going to sentence the defendant to 60 days in Portage County Jail. On the unauthorized use of property, misdemeanor of the first degree, I'm going to sentence the defendant to 180 days in jail. Those sentences will run concurrent to one another. I'm also going to assess the defendant a $1,000 fine and court costs. I will suspend the balance of the jail and $700 of the fine on the following conditions. First, you will be placed on basic probation here in Portage County for a period of 24 months. Second, you'll pay your court costs and fines within 24 months. If you cannot pay, I will allow you to do community work service of up to 40 hours a week at $10 per hour until paid in full. Your court costs are currently $121, so to work this off, you have to do around 42 community work service hours. You will pay restitution of $1,304 in 24 months through the Adult Probation Department here in Portage County to the victim, Brimfield Police Department. You will be persona non grata at the Brimfield Police Department, and you will have absolutely no contact whatsoever, directly or indirectly, with the victim in this matter. Lastly, you will surrender your OPATA certificate under Section 109.77 of the Ohio Revised Code. It's my understanding at this time you don't have the physical certificate, but you are surrendering your right to be a peace officer in the state of Ohio. Do you understand that, sir?
Yes, ma'am.
Sir, if you violate any of these terms or conditions, I will impose the original jail sentence on each count to run consecutive to one another. Do you understand that?
Yes, ma'am.
Anything else at this time, Mr. Pierce?
No, Your Honor. Thank you.
Anything else, Mr. Tomorrow? Not from the state. You'll need to go over to the Adult Probation Department today and sign up with the Probation Department.
Thank you.
David Oliver repeatedly shook his head, took long pauses, and was clearly hesitant before he finally entered a plea of no contest to 4 of his misdemeanor charges, including 2 connected to the mistreatment of the female officer. Portage County Judge Lori Pittman sentenced him to 2 years of probation and ordered the suspension of his law enforcement certification, effectively prohibiting him from working as a police officer in Ohio ever again. If you think that Officer Joubert crossed his limits, wait till you see the next case.
Get on the Greg, get your hands out of your fucking pockets. Bro, don't dude, move that. Dude, put the... He's got a gun, he's got a gun.
This is Mario Ortega, a 35-year-old man who found himself at the Lakeside Motel on the fateful night of July 14th, 2023. Around 12:16 a.m., a deputy from the Adams County Sheriff's Office self-dispatched to the scene. Surveillance footage captured the moment when Ortega, parked outside the motel, was approached by the deputy. As Ortega stepped out of his SUV, accompanied by a woman, the deputy emerged from his patrol vehicle, drawing his gun in a tense display of authority.
Let me see your fucking hands. Let me see your hands. Get on the ground. Get on the ground. Get on the ground. I'm gonna tell you one time, bro. Get on the ground. Get on the ground. I'm gonna punch you in the bro. Get on the ground. Get on the ground. Get your hands out of your fucking pockets, bro. Don't dude. Move that. Dude, put the. He's got a gun. He's got a gun. 271. Shots fired. Shots fired. Shots fired. Let me see your hands. Let me see your hands. 271. Suspect is down. Suspect is down. Female is walking on the second floor towards room 20 or 17. Secure. Hey, man. Go ahead and start medical code 3. Hey, man. Hey, stay with me, bro. Hey, stay with me, bro. Hey, man. Stay with me. Stay with me. Hey, bro. Stay with me. Secure that gun. Stay with me. Hey, man, stay with me. Stay with me, bro. Hey, I need you to trade out with me. I need you to trade out with me. Is it a chest seal? Yeah. Just go. Do you have a chest seal? Yep. I can't find the entrance. Right here. Right here, right here. Hey, female's walking around up here somewhere. Just keep an eye out. She's wearing all black. Come on. The gun's right there. Hey, secure this gun real quick. Okay. Hey. We're here. You're good. Locked out. Hey.
Female, all black, somewhere.
She's walking around. Last time I saw her, she's walking this way up top. Okay. What I need right now. Okay. I need this entire place locked down. Okay. So start clearing these cars so medical can get in here. Okay. Get him out on the street. Are
you 64?
I'm right here. Yes. Get him out on the street. That way.
I'm gonna go.
Okay. Hey, and. Hey, where'd the gun go?
I got gun. I'm gonna go.
Okay.
Despite efforts to save him, Ortega passed away to his wounds after being transported to a nearby hospital. In the aftermath of the tragedy, Ortega's family revealed his criminal past but mentioned his recent efforts to turn his life around in Greeley. They announced their intention to pursue legal action through a civil lawsuit. The investigation into the alleged wrongful acts of the officer are still going on. The deputy involved has been placed on administrative leave, which is standard procedure, and any changes to his status will be determined after the investigation is completed.
Your counsel mentioned rehabilitation. What does that mean to you?
Well, rehabilitation is changing rehabilitation be changing behavior, in my mind, in order to not move away from different outcomes.
This is Officer Michael Amot, 37 years old, from the Euclid Police Department, who in 2017 conducted a traffic stop on Richard Hubbard after noticing that the vehicle's license plate was registered to an individual with a suspended driver's license. During the stop, Amot alleged that Hubbard resisted arrest and proceeded to repeatedly punch him. Later on, in August 2019, Amot was arrested and charged in Euclid Municipal Court after following an extensive investigation. However, due to the disruptions caused by the COVID-19 pandemic, his trial was postponed for 2 years, ultimately resuming in 2022.
Good morning.
Good morning.
Thank you to the court for allowing me a few minutes to speak. It's been a long road. I was 31 years old at the time of this incident. I'm 37 today. As I get older, I tend to put things in perspective more. We're all molded and shaped by our experiences in life and the outcomes of those experiences. This incident is no different for me, and I learned a lot as I look back. I know I've certainly changed in many ways. far from a perfect person. The one thing I've always done is look back and reflect on my mistakes and failures. It is very important for personal growth. History is a great teacher. The only problem is you can never change it. You can't rewrite it. You can only learn from it. It feels like we've been polarized to feel that people on both sides of this topic are either all good or all bad. But the truth is more nuanced than that. The procedure leading up to this moment has exposed me to what defendants are really up against once they're accused in this system. This case was investigated by numerous outside agencies. With the media attention the case got, it certainly should have been. After all, investigations are a search for the truth. I want the public to know what really happened to get us to this point. From day one, I cooperated fully with my own department investigation, Cuyahoga County Sheriff's Office Use of Force Investigation Team, and the FBI. I was repeatedly interviewed by numerous investigators in 2017. I never downplayed my actions. These investigations were reviewed by my local department, county sheriff's deputies, federal agents, local prosecutors, county prosecutors, and federal prosecutors. At the conclusion, I was never charged by the city, the state, or the federal government. 2 years after this incident, in 2019, the special prosecutor filed charges after negotiating a salary of $250 an hour. Pre-trial stretched on for another 3 years before trial. During the trial, I was disappointed that the jury didn't get to hear about the findings of those investigations or to hear from a single investigator. I was also disappointed about how known falsehoods were allowed to be presented like the truth. One of the most shocking examples was a prosecution witness called who testified that I was celebrating in the aftermath of this arrest. He testified that I was high-fiving, fist-bumping, and dapping it up with other officers. There was 5 police cars on East 228th Street that day, all with their dash cameras on and rolling. They all had overlapping fields of view. I can be seen in front of one of those cameras the entire time I was on scene until I was transported to the hospital. Nothing remotely close to what the witness described happened with me or any other officer on the scene. They knew this and put the witness on the stand anyway. This was a use of force encounter that divided a community. It is something I've replayed in my head for the better half of a decade. This is not something I've ever celebrated. I take full responsibility that there was a failure on my behalf to get Mr. Hubbard in custody quickly. The incident was prolonged when I was shot with a taser. During the deployment, I broke my hand, ruptured tendons, and injured my shoulder. When most people see a violent encounter like this, they usually ask, are officers allowed to punch people? And if so, under what circumstances are they allowed to do it? For me, it was important to attempt to educate the jury as I was educated as a police officer. I called every relevant instructor I had to the stand. Taser instructors I had, Department Use of Force instructors, captain in charge of the Use of Force Committee, my Police Academy Use of Force instructors, and traffic stop instructors. I hired a national use of force expert who reviewed everything. Each of them agreed that I acted within the scope of my training. Use of force is supposed to be judged from the perspective of a reasonable officer in light of their training and experience. Every officer testified that my response was consistent with the law, policy, and training. We also submitted handbooks, training documents, and videos supporting the testimony. Regardless of how I feel about the situation, I accept the jury's verdict. However, it's become clear that there's a disconnect between how officers are taught to react and how the public expects officers to react. I cannot change the outcome here, but I can make positive changes going forward. I have to figure out how to move forward and make sure I don't end up here again. As a community, we have to figure out how to come back together and make sure we don't end up here again as well. Our law enforcement training must keep officers safe and also be consistent with public policy. A lot of changes have been made since 2017. And if you can give me just another moment, I'm going to talk about a lot of the changes that I've made and the department's made. During the aftermath of this incident, the department started looking at alternative use of force training that does not rely on striking. Several officers were sent to become Gracie survival tactics instructors. These instructors now teach a revolutionary defensive tactics system based on Gracie Jiu-Jitsu. These tactics are more effective at subject control. Instead of pain compliance through strikes, kicks, tasers, etc., it utilizes mechanical control holds and body positioning. I think the leadership of my department would attest that I've championed these efforts. Early data from one department utilizing this program regularly shows a 48% decrease in officer injuries and a 53% decrease in suspect injuries based on deployment of Brazilian Jiu-Jitsu in their patrol division. The department found that physical confrontations with suspects were 200% more likely to be injured by an officer that did not have the same training. They also reported a decrease in taser usage and workers' comp claims by $70,000 per year, which was significantly less than the cost of the program. I'm proud to share this is now part of our Euclid Police Department's annual defensive tactics training program. Previously, I had 4 hours of training every 3 years. Now the training is completed at least on an annual basis. I've personally taken at least almost 100 hours of training outside the police department and around the state pertaining to use of force and human relations since this incident. The Euclid City Council has provided funding to officers, giving them the option to seek additional training, additional use of force training on the officer's own time at a local Gracie Jiu-Jitsu school. The school is owned and operated by another local police officer. I've taken full advantage of this opportunity so far, and out of all the officers participating in the program, I've advanced the furthest and attained the most rank since this training program began. Euclid received some grant money through COVID. I worked with a group of officers to get some of that money to build a new use of force training room. We were given approximately $20,000 for materials to price, design, and build a new defensive tactics training area. I helped design the new room. I personally constructed a large 1,120 square foot training mat, complete with wall mats and department logos. I put in every screw, nut, and bolt into the new training area myself. We've never had anything like it before. I worked with one of the defensive tactics instructors to create waivers so we can use the new training area on our own time, using department techniques to get the repetitions we need to not only be more effective on the streets, but to keep suspects and officers safer during these encounters. I want to end by saying I'm not an advocate for or against use of force. Everything I did on that day was based on my training and experience. From here on out, I'll be an advocate for subject control training department-wide going forward so we can all be at our best when the time comes. I have a deep respect and love for the citizens and this community. I want to do my best to serve them. After all, it's what they deserve. Thank you.
Thank you.
Officer Amiot's address does reflect his commitment to minimizing the use of force against people, but it fails to demonstrate any empathy towards his victim, Richard Hubbard, something even the judge notices and points out.
Officer Amot, your counsel mentioned rehabilitation. What does that mean to you?
Well, rehabilitation is changing stand up. Sorry. Well, rehabilitation can be changing behavior, in my mind, in order to not move away from different outcomes. So like in this case, for example, we got here for, I believe, punches in the duration of the fight. If there's a better way or faster way to do it, then the police department's looking into ways to do that. So a lot of that's being taken, for me, training at my own time, and the department's done it. That's rehabilitation to me is changing behavior.
You know, I'm listening to everything that was said by everyone, and particularly what you were saying. One of the things that I did not hear, you did not address Mr. Hubbard at all. And I'm not saying it's something that needs need to be done, but it's an observation that I made. And part of that, I try to observe and see what's going on and listening. And you can be seated. I'm going to talk a little bit here. I just wanted to ask that question. I didn't just sit here and let the trial pass me by. I observed the testimony from everyone. I listened. One of the things that stood out to me is that the initiation of this incident probably never should have occurred. When you receive that initial radio communication, that initiated this whole thing. And the other thing that sort of stood out to me was that in approaching the vehicle and asking Mr. Hubbard to get out of the vehicle, from my perspective, there was an inability for him to get out of that vehicle without making contact with you. Inability to get out of that vehicle. I appreciate the things that you said about mistakes and failures, the amount of investigation that's that took place as a result of that, and I appreciate all of that. I personally spent over 30 years in the military, so I'm used to having orders, following orders, obeying orders, a regimented order of things. I'm accustomed to that. And I appreciate the necessity of police having the ability to, we need them. We need them to do their job appropriately. And when we deviate from that, then we have to do what we need to do to ensure that it doesn't occur in the future. And I appreciate what Euclid has done, the Euclid Police Department has done with respect to modifying how contact is made and how you get people under control. And police need to be able to control folk, no doubt about that. There must be control. But there's a limit to how that's done. And based upon the evidence that was presented in the testimony, and I did listen to your trainers, your prior instructors, I did listen to them. But I do believe in this case, I believe the jury got it right. I do. And the court must impose the sentence that the court feels is appropriate in a case like this. And I appreciate the information provided in the pre-sentence investigation. And generally, I'm the type of person that generally follows recommendations, generally speaking. I'm not here today to send a message to the world. I'm here today to evaluate what occurred here And especially given the length of time that has expired since this incident and to today, take what I think is the appropriate action in imposing a sentence. How long did Mr. Hubbard spend in jail?
I think an hour or two.
An hour or two. Okay. Okay. Good. That's a good thing. Mr. Hubbard, let me say to you, it's been 7 years.
Yes.
The city of Euclid compensated you.
Yes.
If you need assistance, you need to go and get that assistance. But I'm not going to say you're not going to have instances of flashback or what have you, but you need to move on with your life also.
Oh, yeah, yes, for sure.
And not let this incident continue to hover over you. The city compensated you. Counsel, I appreciate your comments with respect to the things the court is required to take a look at in imposing a sentence. Based upon the evidence presented and the pre-sentence investigation, the court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000, and will require you to pay the court costs. In addition, the court will suspend the sentence of 90 days, place you on non-reporting community control for a period of 1 year. If you violate during that 1 year, then the court will retain the ability to impose the sentence. Anything on behalf of the state?
No, Your Honor.
On behalf of Ms. Damian.
Just what count is this in? Court electing a sentence?
What count? While Mr. Hubbard's rights were violated, and the officer, as an officer, he used his authority to do that. However, given the length of time involved here, the court will use the assault as opposed to the violation of civil rights. Not saying they weren't violated, but given the length of time, the court will use the assault charge. Anything else?
No, thank you, Your Honor.
That's all. Good luck to you, sir.
Thank you.
I'm still troubled by the fact that you did not address Mr. Hubbard.
I can address it. No, that's all right, Your Honor.
No, it's not all right.
I don't need it.
You do need it. You say you can't move on. I'm telling you, you need to move on. Not easy. Life is not easy. But as long as you let that handicap you, he has control. As long as it handicaps you, he has control. You make that decision, sir. Do you want him controlling, or this situation to control you?
No.
You need to think about that. That's all.
All rise. Court is now adjourned.
You all do what you want to do.
The jury convicted Amot on 1 count of misdemeanor assault and 1 count of interfering with civil rights. As a result, Euclid police officer Michael Amot received a sentence of 1 year of non-reporting community control and a $1,000 fine for the assault on Richard Hubbard. Initially, visiting Judge Guy Reese also imposed a 90-day sentence, but the sentence was later suspended. Charles' case definitely went quite peacefully, something that we can't say for the next one.
It is the judgment of the court that you be sentenced to 6 years confinement in the Texas Department of Criminal Justice Institutional Division. That will be suspended. You will be placed on probation for 5 years. There's a $2,500 fine plus court costs. No restitution is ordered in this case.
This is Michelle Barrientos-Vela, a former Bexar County Precinct 2 constable. She was taken to court for 2 felony counts of tampering with records. The verdict came after she presented falsified Rodriguez Park security payment logs during a criminal investigation.
If you could please stand so that we can proceed to sentencing. Mr. Goss, is there any legal reason we cannot proceed to sentencing?
Oh, yeah.
It is the judgment of the court that you be sentenced to 6 years confinement in the Texas Department of Criminal Justice, the Institutional Division. That will be suspended. You will be placed on 5 years probation. There's a 20.
After the announcement of her punishment, chaos broke in the court and it took a while for things to settle.
Come on. Close the door.
I did not hear.
I'm going to start over. It is the judgment of the court that you be sentenced to 6 years confinement in the Texas Department of Criminal Justice Institutional Division. That will be suspended. You will be placed on probation for 5 years. There's a $2,500 fine plus court costs. No restitution is ordered in this case. You will be ordered to satisfy 600 hours of community service. 1/2 of those hours I will allow you to buy out by contributing to the San Antonio Food Bank at $10 per hour. The remaining 300 hours you will satisfy by working for Habitat for Humanity at a location I will designate. There is to be a no contact order with Leonicio Moreno, no contact order with Anthony De La Cerda. I am ordering a $50 contribution to Crime Stoppers. I'm also ordering a moral recognition therapy course. You will complete that course. I will be satisfied if you buy the workbook yourself. I'm not going to require you to go to the group therapy sessions. Confinement. As a condition of your probation, 90 days confinement in the Bexar County Jail. I am going to hold that in abeyance until the results of the appeals are exhausted, but I am ordering it, I'm imposing it once all of that is finalized, and I will decide how you will serve that confinement. I have options. Lastly, your probation starts today, ma'am. Look at me. Your probation starts today.
Michelle Barrientos-Vela was sentenced to 5 years probation, 90 days in jail, and 600 hours of community service after being found guilty of 2 felony counts of tampering with records. Although things did get crazy during her case, she remained calm, unlike the next corrupt cop.
I'm going to prohibit your physical or constructive possession of firearms or ammunition at any time for any reason.
This is Joshua Underwood, a former deputy sheriff with the Oconee County Sheriff's Office. On February 28, 2019, he appeared for a bond hearing at the Oconee County Detention Center after a tense situation unfolded at an apartment complex on South Oak Street in Seneca, South Carolina, where Underwood was residing. Underwood was being charged with opposing or resisting a law enforcement officer serving process. And here's how that turned out.
All right, Mr. Underwood, I find the solicitor's request for a cash or surety bond of $50,000 to be reasonable accordingly. I'm going to impose that cash or bond for your release.
After the announcement of his bond, Joshua isn't too happy.
I find it absurd that you haven't even obtained any information from me based off the solicitor. You're going to believe everything that he says.
Okay.
And you're going to go ahead and set a surety bond on me on a misdemeanor.
Okay. Are you finished? Okay. If you'll hear me out, please. Thank you. Additionally, I'm going to place a requirement for a GPS monitor prior to your release on bond. I'm going to restrain or restrict your contact with your domestic partner or the mother of your child, whichever best describes her, to include her place of work and her residence. Additionally, I'm going to prohibit your physical or constructive possession of firearms or ammunition at any time for any reason. And I want to make sure that you understand, when I say constructive possession, I mean there's to be no firearms or ammunition in any vehicle you're being transported in or riding in unless it's...
What grounds? Are you prohibiting me from firearms?
I am.
Why? What grounds?
I am. Because I have that latitude given the severity of...
What reason is your
Sir.
Why are you standing behind it that you're gonna
Mr. Underwood,
firearms?
Mr. Underwood, in this court, one person talks at a time.
From the solicitor's office and the sheriff's office.
You're going to find yourself in contempt of court.
I've already been in contempt.
Okay.
I'm not here, sir.
All right. Are you going to allow me to finish? Constructive possession of firearms or ammunition means you will not have it in your possession. It won't be in the house or the room that you're staying in. It won't be in the vehicle that you're being transported in, unless we're talking about transport by law enforcement. Do you understand that? All right. That's all. You're dismissed. Officer, if you'll remove him.
You can't look at me, can you? You can't look at me, can you? Which one? Which one?
Joshua continues to talk angrily with the judge while he tries to get him to calm down. Underwood's bond hearing shed light on the legal proceedings following his arrest. A judge set his bond at $50,000 and mandated the use of an ankle monitoring device should he secure his release. But if you think that it's the end to such horrendous cases, then you're in for a surprise with the case of Police Chief Scott Gardner.
Yeah, it's been 2 years since I've been able to talk about this, and I greatly do apologize. I apologize, first off, for wasting the court's time, wasting the state of Ohio's time. It was never my intention to have this underreported. And as Ms. Hibbert expressed, as soon as I found out what was happening, and the state makes the allegation of why I did it after the subpoena. Well, I didn't know there was anything wrong or going on until I received the subpoena.
This is Scott Gardner, aged 49, a former East Cleveland police chief who was indicted in August 2022 on various counts, including theft in office, telecommunications fraud, and tampering with evidence. In the summer of 2023, he was re-indicted, and prosecutors added counts related to filing fraudulent tax returns, money laundering, and new theft offenses.
Mr. Gardner is sorry for what happened. He absolutely is remorseful. This has been very, very difficult for him. He has asked me on a number of occasions, what am I going to do? I have to make sure that this never happens again. Like it worries him. He doesn't want to engage in this sort of behavior. He doesn't want to be seen as somebody who would steal from the state of Ohio. Mr. Gardner is a person that cares about others. I can say that from my personal experiences with him. I can say that from the way I see him interact with others. He is a very kind man. He is generous. He would help anybody with anything. He really would. It's just his nature. I know I had said it before, but just as generous as Mr. Gardner is with others, he would pay for things for others. You saw that in the letters. He would buy other people things if they needed them. He put his own money into the department. He put his own money into the FOP. And maybe some of the money was that. But Mr. Gardner is, not only did he do those things, but he is trying to pay that back. And he's paid a significant portion of that back. And he will continue to make payments on that. He's dedicated to doing that. He's dedicated to taking care of his responsibilities. And he cares about other people. Him attempting to be a cheat or a thief or anything of that nature is not his intentions. It's really not. Mr. Gardner is a caring person, and I think that he is going to now tell you how he got into this situation, and he would like to apologize to the court and the state of Ohio.
Your Honor, thank you. Yeah, it's been 2 years since I've been able to talk about this, and I greatly do apologize. I apologize, first off, for wasting the court's time, wasting the state of Ohio's time. It was never my intention to have this underreported, and as Ms. Hibbert expressed, as soon as I found out what was happening, and the state makes the allegation of why I did it after the subpoena. Well, I didn't know there was anything wrong or going on until I received the subpoena. I immediately took action. I fully acknowledge that that money is not my money. The money was accepted, as I've learned, that I should not have accepted or kept. So I fully acknowledge that, and I fully prepare. Since that time, I've had certified public accountants filing my sales tax with the interim of my CPA actually firing me because of this incident recently. But my intention is to make certain that this does not occur again. This is not who I am. This is not what I want my perception to be for the remaining time. And I appreciate the time, Your Honor, for me to be able to speak.
I want to be real clear, Mr. Gardner, because I don't want you to have any false impression about the impression that you've made on me. This isn't just reckless on your part. I don't believe that for 1 minute. Not for 1 second do I believe that you're just a poor bookkeeper. We're talking about a factor of over 10. You paid $1,000 when you were supposed to pay $12,000. You paid $3,000 when you were supposed to pay $49,000. That's not an oops. That's not I just am a sloppy bookkeeper. That's a person who essentially was, and maybe Ms. Hibbert is right when she says that you did good things with some of that money, but you were essentially robbing from Peter to pay Paul. And I don't buy the argument that it was just an oversight. And as soon as it was brought to your attention, you said, oh my gosh, let me correct this. I believe you believe that you could just do this, get away with it, nobody would notice. But for the phenomenal investigative work done by the agents who testified in this case, I think you never would have paid this money. So I don't buy that argument. I don't buy the sloppy bookkeeper argument. It doesn't fly. I listen to the testimony. Sometimes when cases aren't tried, as judges, it becomes difficult to assess what really happened because you don't get to really hear the facts of the case as much as you do when there's a trial. But here it was abundantly clear that you just were kind of running a scam. I mean, we're not going to get too deep into it because a lot of the counts were dismissed against you. But there was an awful lot of testimony that I heard that signaled a guy who was willing to cut corners. That's who you are. I mean, let's not kid ourselves, right? This is your third time in the courtroom, or is it fourth? Third or fourth time?
Third, Your Honor.
All right, so we have two separate instances where you've been charged with this sort of behavior, right? The first time it happens, you might say, oh my gosh, whew, here I am, a police officer. I've been charged in Portage County for misconduct revolving around a cigar shop I own. You might say, well, you know, I'm a fine police officer, but I'm a bad cigar shop owner, operator. I've got to do better. Then you get another case and you say, oh my God, I can't believe this happened again. I've got to do better. Now a third time and we're supposed to write that off as just another oops. That's nonsense. I don't buy it, not for 1 minute. That's not to suggest that Ms. Hibbert is wrong when she says that there's good in you. I'm certain that it's true. But you were stealing. To come in here and say something else is somewhat offensive. In the end, though, what you pled guilty to was a single fourth-degree felony with a presumption in favor of community control. And as judges, we're not just throwing darts at a spinning board and hoping that we hit the right sentence. We use the guidance that we're given. And this is a non-violent offense. You have no felony criminal history. So this is your first felony conviction. I don't see that as a small matter. I see, particularly someone who's spent their career in law enforcement, having to carry around a felony conviction as a significant thing. So although I'm in no way fooled by your story of the hapless business owner who just can't shoot straight, I'm not going to overreact and incarcerate you today. I don't believe that police officers when they commit crimes that are really unrelated to their business, ought to be treated more harshly than, say, a butcher, a baker, or a candlestick maker. You know, the fact of the matter is, I'm going to sentence you like I would anyone else charged with a low-level, non-violent felony of the 4th degree who has no prior felony criminal history. So, although I certainly appreciate why the government might be inclined to ask for prison here, I think it would be an overreaction. I think it's unfair to people who have committed their lives to law enforcement, which is a real honor to be able to say that my job is to protect and serve the community. I mean, that's a real honor. But I don't think that the payback for having committed yourself to a life in law enforcement is for judges to immediately send you to prison and apply some sort of police officer specification. That means whenever a police officer commits a crime, they have to go to prison when another person wouldn't. I don't think that's appropriate. So I'm not going to incarcerate you, even in the face of your foolish explanation as to why you did this. You need to take some time while you're on probation and do some soul searching and figure out what your life plan is going to be. Because cutting corners and running raggedy businesses where you steal from the state hasn't worked for you. You're now a convicted felon. Here's where it gets a little bit more interesting. Now that you are a convicted felon and you're about to be on probation to me for the next 5 years, if I even get a whiff, a sniff, that you're cutting corners out there in the world, that you're running some kind of a business and maybe not doing the things that you're supposed to do, that maybe you've put a business in someone else's name and you're teaching them how to cut these corners, if I find out about it, you're going to prison. Do you understand me?
Yes, Your Honor.
Is there anything unclear about that?
No, Your Honor.
You're going to have to pay this restitution. You will be responsible for, what is it, $149,000? $149,954.50. That restitution will be a condition of your community control. If I sent you to prison, it would make it more difficult for you to repay that debt. So that's one of the other benefits of you being able to be in the community. And in addition to that, you know, it's also not lost on me that you tarnish the badge when you do this. Now, you didn't do it relative to your work as a police officer, right? This wasn't something that you used your role as a police officer to sort of get away with the crime. But look, let's be clear. The reason why all these cameras are pointed at you is because you're a police officer, not just a police officer, but chief of police who has fallen this far. It stains the badge. It blemishes the badge. You're going to have a consequence that's tangible, not just the intangible consequence of a felony conviction. You're going to give back to the community. This went on for many years. Going back to 2014, our window is a 6-year window. So with that in mind, you're going to do 600 hours of community service. 100 hours for every year that you engaged in this scam. And that's what it was. It was a scam. I don't be repetitive, but the sloppy bookkeeper story is not believable for a guy that's been in court on 2 separate occasions for similar conduct. So for each year you engaged in this scam, you'll do 100 hours of community service. I would certainly, I would never, over any point in that 5 years you're on probation to me, I'd never forget that I'm giving you a chance, that your judge gave you a chance, right? But that's all it is. If it turns out that Ms. Soul and the state of Ohio is right, and you just don't have it in you to do good, then you'll make a mistake over these 5 years, and you'll end up going to prison. On the other hand, I hope that just like me, on some level, the state of Ohio is rooting for you to do well, right? The goal of this is to see people not recidivize. The goal of this is to correct behavior. And there ought to be punishment. The punishment is the 600 hours of community service. But the hope is that over the course of the next 5 years, even if it's only out of fear, the state of Ohio won't have to worry about you stealing from the state anymore because of that that heightened anxiety that your freedom is at stake. Do you understand?
Yes, sir.
Normally, it's the court's inclination to create incentives for people to do well on community control, and so I always look for ways to consider terminating community control early. So I would commonly put people on maybe 5 years of community control, but I'll say, look, if you can show me a year of sobriety, 12 straight months, we'll terminate your probation. But I want you to understand, I'm not going to do that in this case. I want there to be some certainty that you're being supervised for as long a period of time as I possibly can. So that's the maybe the one dissimilarity to the way I'm treating you and I might someone else. I want you to be supervised for as long as the law allows me to do it, and that's the 5 years. So while you're on community control, you'll report monthly. You'll be drug tested. You will have to maintain verifiable employment. You are on a habitual offenders list, so you can't operate a business in the state of Ohio. You'll have to have some sort of verifiable employment. I'll give you some flexibility there because I understand that you are retired, but there's going to have to be some work. You'll have to show that you're doing some work in addition to just the community service. As I indicated, you will be drug tested. I don't know if there's a drug issue here. Maybe there's not.
None whatsoever, Your Honor.
That's fine. I'm happy to hear that. But on the off chance that there should come a time where you test positive for an illegal substance, I want you to understand, I'm not going to incarcerate you for that. We'll talk more, and we'll figure out a way to help you if there is a drug issue that should arise. And to that end, I want you to be forthcoming with our probation department. If there are issues that you have that maybe haven't been addressed in open court, maybe they're too private to discuss in open court, discuss them with your probation officer. Develop a relationship with the probation officer so that you can speak with that person. We have a fantastic probation department. Bless you. I certainly hope that you're able to pay this money back. I don't want you to think that just because maybe on some level I've had some harsh words for you, Mr. Gardner, that I want to see you do poorly. To the contrary, my hope is that this sentence will have the net effect of you doing well and extricating yourself from the system and never having to go through this again. Do you understand?
Yes, Your Honor.
Ms. Soul, anything else on behalf of the state?
No, Your Honor, we would just ask the journal entry to reflect the restitution amount.
It will be in the journal entry.
Thank you.
Ms. Hibbert?
Nothing, thank you, Your Honor.
We're adjourned.
All rise.
In March 2024, Mr. Gardner pleaded guilty to one of the tax-related charges in a plea deal that dropped the other 23 counts against him. Between 2014 and 2019, Gardner failed to pay more than $203,000 in state sales taxes from his private security business. According to Cuyahoga County Assistant Prosecutor Samantha Soul, Gardner was placed on probation for failing to pay taxes in 2 other cases in 2014. The same time, he started failing to pay his taxes in this case. Considering all the offenses, Mr. Gardner was sentenced to 5 years of probation and 600 hours of community service for tax charge. It is astonishing to see cops committing such heinous crimes, but at least some of them are on camera getting their deserved punishment. But even this case was not as shocking as the next one we are going to share with you.
I'll get in that truck and leave.
Well, that's fine, but then I'm going to have to arrest you.
Go ahead.
You're staying here, sir. You're not leaving.
I'm leaving.
No, you're not.
This is Clyde J. Giblin, a resident of Colby, Wisconsin, whose life changed dramatically after an encounter with Marathon County Sheriff's Deputy Troy Dealer and his police dog Leo on August 6, 2015.
Morning, sir. How are you? I see a business name on your excavator here. Are you running a business?
Why?
Are you doing work right now?
Yep.
Where are you headed to, if I might ask?
Dorchester.
And the reason I ask this is I don't see a name or a USDOT number displayed on your truck?
State trooper told me I don't need one.
You would, sir.
I'm not for hire.
Well, whether you're for hire or not, you're still considered a commercial motor vehicle. As long as you make a buck, you own a business, and you're going to a job site, you're considered a commercial motor vehicle.
What am I supposed to do?
Well, you have to obtain your USDOT number. That's first off.
I'm not going to do that.
And then,
I got to get going.
Well, you're going to have to wait until we're done with the inspection.
I'm not going to wait either.
Well, you'll have to.
No, I don't have to.
Yes, sir, you do.
Don't tell me, hey, I have to.
No.
I'll get in that truck and leave.
Well, that's fine, but then I'm going to have to arrest you.
When the officer initially threatens the man simply refuses to be arrested and claims he'll just leave.
Go ahead.
You're staying here, sir. You're not leaving.
I'm leaving.
No, you're not.
I got work to do.
No, we're going to go through this inspection and you need to settle down. That's fine. You're going to be placed under arrest.
After the cops stop the man, their dog decides to act up.
70 left on Pine Road. You're on Pine now.
264, you're covered.
After the incident, Giblin filed a lawsuit against Deputy Dyler alleging unconstitutional use of force and seeking damages for the physical and emotional trauma he endured. The lawsuit highlighted the permanent scarring, medical expenses, and business loss suffered by Giblin as a result of the incident. A lot of these corrupt cops definitely got what they deserve. From making unlawful demands to abusing their power, corrupt cop cases appear regularly, but unfortunately, not all get dealt with. If you enjoyed this video, let me know in the comments below and don't forget to subscribe. Goodbye.